Hello again, students. We are now on the second floor of the courthouse in one of the two courtrooms. This is Judge Sharon McCally, who is one of the judges that sits on this panel here in this courtroom. And she is going to talk to you about what an appellate court does, what she does here, how cases get here, and that sort of thing. Judge McCally.
I'm excited to. I'm happy that someone has interest in it, because usually what students have interest in is a trial court where all of the excitement really happens. I'm sure that you have told your students about how cases are tried. There is, in civil cases, a plaintiff and a defendant, and a jury decides the facts. In criminal cases, it's much the same, only it is the state and the accused, and a jury decides the facts. But very few people hear what happens next. That's where we are now. What happens next is that the party that didn't win below files an appeal. As a justice on the Court of Appeals, this is the 14th Court of Appeals. We have 14 separate courts of appeals in the state of Texas. We have the jurisdiction to hear appeals from both those civil cases and those criminal cases. That's unusual. We're only one of a couple of states that do it that way. So a Court of Appeals justice such as myself will get to look at the paperwork for someone who did not win below. That's called the appellant. The appellant will come and ask us to reverse the case that was decided by the jury. We take that case, we review what is filed in the case, which is the briefs. We meet and decide these cases in panels of 3. Now let me back up for just a minute and tell you that the 14th Court of Appeals is only one of 2 that we have in Houston. The 14th Court sits in this courtroom, and the first Court of Appeals, the first one ever created in the state of Texas, sits across the hall. There are 9 justices on that court and 9 justices on this court. We decide each individual appeal in panels of 3. So at any given time, there are 3 judges, 3 different panels deciding cases. It is very rare that a case would command all 9 justices on the 14th Court of Appeals to sit together, but when we do, we call that the en banc court. Those are very exceptional cases, usually when we are going to overturn something that we have decided previously. So whatever panel I sit on, if I sit on a particular panel and decide a question of law, all other panels on the 14th Court of Appeals are bound to follow that law. We don't make these things up anew every day. We have to follow precedent. That concept is a Latin term called stare decisis. So then back when we received our papers in an appeal, 3 judges will get together on a panel and look at a case. We will decide preliminarily from the briefs and from the law that we have researched with the assistance of our staffs how we think the case will come out, and whether or not we think we should bring the parties in to argue the case, to have oral argument. Not every case has oral argument, but many do. This courtroom is what we use for oral argument, so it sits empty fairly often. But when the litigants come in here for oral argument on their appeal, you can see there's no room for jury here. 3 of us would sit in the middle, and the plaintiff or the appellant, the person bringing the appeal, would sit on one side or the other, and the responding party would sit on the other side. They step to the podium, and they each get 15 minutes to argue their positions to us, and we hear their oral arguments. We get to ask questions, unlike in a jury trial where the judge and jury don't ask questions to help them decide the case. We actually ask questions of these parties. We ask them what happened in the trial below. We ask them about policy questions. If we decide a question of law in a particular way, what happens to other cases? So we ask these questions. When they finish with their appeal, we retire to our roving room and we discuss the case again amongst ourselves, and we decide how we believe the case should turn out. Whichever justice is preliminarily assigned to the case will then work up a draft of that opinion and circulate it to the other 2 justices, and we have a give and take. We sort of argue and fight over, and that's how your law is made at the Court of Appeals level. Ultimately, we come up with a decision or more decisions. If I write an opinion and my co-justices do not agree with me, but one does, then we might have a majority opinion, that is 2 justices, with a dissenting opinion, a disagreeing opinion. And then if the parties are not happy with how they come out in this court, then, as you probably told your students, they then go up to the next court. If we've decided a criminal case, they go up to the Court of Criminal Appeals. If we've decided a civil case, they go up to the Texas Supreme Court.
Now, tell us what are the issues that the 2 sides are presenting? It's different than what was presented in the trial court.
That's correct. Generally speaking, The jury has resolved questions of fact, and the judge has resolved questions of law at the trial court below. When the jury decides a question of fact, it is not to the Court of Appeals to decide whether they were right or wrong. What comes to the Court of Appeals is a question of the sufficiency of the evidence. That is really the only way in which we review jury verdicts, whether there was sufficient evidence to do what the jury did. And the party bringing the appeal has to say and has to demonstrate that there was not sufficient evidence to support what the jury did. So if it's just a car wreck, if it's a civil case and it's a car wreck and the jury decided that one of the parties was negligent because they believe that they went through a red light. Instead of the light being green, they went through the red light. We at the Court of Appeals do not substitute our judgment for whether or not that light was red or the light was green, or whether or not witnesses were believable. We only look to the entire record to see whether there's any evidence to support what the jury did. And if there is, then we must affirm that case. Those are civil cases. On the criminal side, the concept is the same. We do not revisit the credibility of witnesses. We only look to see whether or not the evidence was sufficient to support the conviction of the individual if the appeal is being brought by the criminal defendant.
Now, you also look at whether the judge might have made some mistakes, right?
That is true. And most questions of law we review independently. We don't give any deference, in other words, to the trial judge. But there are some matters of law in which trial judges have discretion. So let's say, for example, one of the parties was complaining because the judge didn't give them enough time. That is a question that is what we consider to be a question of discretion of the trial court. And so we will examine the facts and circumstances, and if it falls within a zone of reasonable, then we will affirm what the trial judge did in exercising his or her discretion. But if, on the other hand, one of the litigants brings to us a question which we consider to be a question of, for example, statutory interpretation, the legislature has written a law and it needs to be interpreted. That is a question of law purely, and we do not accord any deference to a trial court in reviewing those questions. We review them, we call it another Latin term, de novo, but it is without deference, and we make those rulings.
And so if the judge got it wrong, the way he interpreted the statutory law in the case, if you feel he got it wrong, then you rule against him.
We reverse the case and send it back for the trial, that same trial judge to handle the proceedings based upon the interpretation that we have issued. Having said that, you've mentioned to your students the various levels of the courts. I'm talking about deference. We are at the Court of Appeals in the intermediate level. We are the last court of last resort on questions of factual sufficiency. But on that question of law that you just mentioned, if we disagree with the trial judge and we reverse and say his or her interpretation of the law was incorrect, before it goes back to the trial judge, the parties have the chance to go up to the next court, because we are not the court of last resort on interpreting statutes. So they may say, we want the Court of Criminal Appeals or the Texas Supreme Court to decide whether or not the Court of Appeals was right in their interpretation of the law. So you have the chance to go all the way up on that law before it goes back to the trial judge to implement the new interpretation of the statute. That makes sense.
Now, the appellate level, the intermediate level, everyone has the right to appeal their case to this level, right?
That's correct.
At this level, litigants can appeal to the highest level, but it's up to those Supreme Courts whether they accept the cases or not, right?
That is correct. An appeal to the Court of Appeals is an appeal of right. We consider it the right of all litigants. An appeal to the next level is an appeal of permission. There's only one type of case that is an exception, a type of case that bypasses the Court of Appeals. Circumstances in criminal cases where the death penalty has been assessed do not come to the Court of Appeals. They go directly to the Texas Court of Criminal Appeals. But other than that type of case, it's appeal of right and then appeal of permission.
Well, thank you very much, Sharon McCally. I appreciate it.
It's my pleasure.
Okay, what did we do? Go right up to our